This class is going to talk about contracts, specifically purchase contracts, and the way in which Halacha approaches making a purchase contract, which is to say, I'm going to transfer something from myself to you. Conversely, I am asking you to transfer something from you to me. So I either have to make an exchange or I'm just receiving it as a gift. How does this process work? So one of the earliest examples we find is in the Torah of a transaction, is we find the word for mechira, meaning a transaction, is Esav comes up to Yaakov and says, "Give me something to eat. I'm starving." And Yaakov Avinu says, "Machra chayom es bechoras chali." Sell me, as of this very day, your firstborn rights. All right, I mean, he doesn't have that. It's not like he walks around with a little sheet that says, rights of Bechor. It's something that sort of floats in the air. It doesn't have any physical assets. There's no appointed assets. It's a right to inherit. But nonetheless, they transact for it. And it says he sells it, and Esav regrets the transaction. So what's funny about that is that doesn't seem to be a valid halacha contract. So the Rambam starts off by explaining how transactions work. This is, 1:1. This is chapter 1, halacha 1 in the Mishnah Torah and the laws of Bechira, Hilchas Bechira, laws of sales. He says, one does not acquire through words. There's not through a verbal agreement. Even with witnesses who witness this transaction. How does it go? All right. I have a house to sell. I'm going to sell you my house. Or I have wine to sell. I'm going to sell you my wine. Or I have something else that's, some type of movable thing. I'm going to sell it to you. We agree on a price. And we see that the purchaser is consenting and says, I'm buying it. And then we see that the seller is consenting and says, hey, I'm selling it. And they look to the witnesses like, we're buying and selling. Take note, okay? This is meaningless. And it's as if there was never anything that transpired between them, says the Rambam, because it was only words. Same thing, too, if you were giving a gift in this manner. Okay? It's basically to say that it's even as if the conversation never happened. It's not that way. What happens? Number 2, he says, if you use one of the methods of transaction by which property can be transacted, then you don't need witnesses. And no one can take it back. It is a final sale. It is a good sale. So how are things sold? Well, there's one way to transact items. There's one way to transact property. We're going to talk more about items today, which is mostly through some type of document or through exchange of money. And we're going to talk a little bit more about that. So we'll talk about specifically what goes into a contract. So you have to have an actual... So we say in American law, you have to have considerations in a contract. Something has to go from A to B. So a Jewish law doesn't allow someone to give you something to somebody else where there's just words between them. So there's another example in Talmud. Let's say two people own a piece of property and they want to build a wall in the middle of it. Okay? So the question is, how do they, they own it together. How do they transact that each one's going to pay for half of this wall? So the Gemara says, okay, so we don't know that they have to split it. So if they decide they agree to split it, what's going to force them to do it? So what we say is that they have to make a formal contract and they have to make an actual transaction. Okay? And this transaction over here is called a kinyan sudar, which is a formal process of memorializing a transaction, and that's how you say that we have made them do this. But then the Gemara says, for 1 second, there's nothing here. They don't have actual physical stuff to transact. But we do eventually settle on this fact that they can't just agree to it. They have to actually make a transaction. So there's a comment from the Meiri over here that the Gemara calls this kinyan dvarim and not a kinyan. Kinyan means you have to actually acquire something at that time. Kinyan dvarim is more like a promise to do something. So you promise to sell you a particular piece of land. I promise to sell you some wine. I promise to sell you some books, but you don't actually take possession of it. So if you don't do something that memorializes taking possession, then there's no contract. And verbal contracts are basically unbinding. You could always say, I don't want to do this. So what we see from the Gemara, that the only way you can have a valid kinyan, a valid transaction, is to basically have a actual transaction to give it legal force. Okay? So this actually stands in contrast to a lot of other cases in law, especially in the times of the Talmud, that if you just made an arrangement, you had to keep it, but no. So that seems to be pretty axiomatic in modern law. It's called pacta sunt servanda, right? We have made an agreement. No, it didn't transact anything. It's not in the contract, and it's not really a big deal. There's another thing that says it's only you need to prove with a transaction that the both parties consented, because sometimes people don't like the outcome of a future event. Maybe things are going to change. There's another problem to demonstrate that a person has full intention, which is called gemiras das, and that's to make sure they don't have asmachta. Asmachta means I'm relying on you. I'm leaning on it. I'm leaning on this thing happening. Okay, but there can't be this amorphous condition for a transaction to occur. Okay, so the cases of asmachta are basically saying, I pay part of the debt. This is a Gemara also in Bava Basra, and it says I pay part of a debt, and then you have to pay back the rest of the debt by a certain date, and if you don't, this third party is going to fill it off, and then I'll come collect from the original guy. So this doesn't work. The Mishnah says it doesn't work, and the Gemara says it doesn't work. And the reason why is because the rule of conditional parts of a contract is non-binding, called asmachta. So if you promise to another person on the condition that they do something in the future, if that doesn't happen, that person may not want to have to make the payment. So therefore, you don't really have a full-hearted commitment to it. And the Rashbam actually says this. He says he's not trapped or bound by his condition because it might equal him suffering a loss. And a person would not agree to simply take a loss. It's almost like gambling. And this, sir, is not a casino. This is a business. So people who transact business by oral agreements, it's really important that you stick by it. But as anyone who will learn other laws of contract, especially if it comes to hiring, when we're not dealing with this now, but when it comes to hiring workers, oral agreements aren't binding. You have to often demonstrate they started work before any of the contract to work is binding. Again, different than transaction. The transaction, you have to have someone actually take possession of something because maybe they don't want to take a loss, so therefore they didn't really agree to it. So, and it's actually interesting is that if someone had paid for an item, so the person is now bound by that contract to go ahead and fulfill it. Okay, so this is actually, the Rambam brings this down back in Hilchos Bechira. This is in chapter 7. So let's say you transacted the money, and so now if you owed some money for it, and you don't finish through with it, you're in breach. How do they call someone in breach? It's called a mishapara, one who is punished. So how do you administer the punishment? You pronounce the following punishment against them. He who punished the people of the generation of the flood and the people of generation of the Midbar, okay, and also punished the people of Sodom and Amorah, and also who punished the Egyptians who were drowned in the sea. Punish one who's not stand by his word, and then you refund the money. So if they're not going to fulfill the contract, it is generally for someone who doesn't fulfill paying for it. Okay. So there are some obligations to it, but it's not. This is not a 100% every single time that mishapara takes place, but that's what happens when you don't fulfill your word. Okay, if you only made a deposit, okay, you get this mishapara. Okay, so this is you return the money. So that's basically when you've already exchanged some money, not necessarily all the money. But the idea is backing out on contracts is not cool. Okay, so there are a lot of obligations to pay in the future in certain contracts. So, it's not like Yaakov and Esav when he was asking for the right of the Bechor. That was the only time in the whole world that would ever happen. No, it happened again another time. It happened. It happens in every single wedding. Every time someone writes a ksuba. So a lot of later rabbis after the Talmud go, how does a ksuba work? The ksuba is I owe you all this money in this document, and it's a lien against my property. Whether or not I own the property now, it'll be collected from it until the very shirt off of my back. We'll pay the ksuba. Not only the main part of the ksuba, which is either the 100 or 200 manos that are the 100, 200 zuz is referred to, the pieces of silver that are the original enactment, but even the dowry part of it and the additions that are added to it by both Ashkenazi and Sephardic custom that was added over the generations, you owe that money. So how does this work? So there's really long Tosfos in Ksubos where he states the following. The Tosfos adds this is Tosfos to Ksubos 54b. Okay, and it says there that but by Tosefes Moneh is what it's referring to. So Tosfos goes, how do I do that? This should be asmachta, as we said. Asmachta shouldn't work. So he says, I'm also transferring something that doesn't exist yet, like Yaakov and Esav. And also putting a lien against property I don't own. These are all my problems. So, famously, Rabbeinu Yitzchak went and asked this question to Rabbi Eliyahu. And he explained the following. So if a person who is paid to watch an item, he can make a stipulation to be treated as a borrower. What does that mean? So he says that they make a valid transaction, a kinyan, with the person watching the stuff, and therefore he can turn himself into a borrower. So meaning a person is not allowed to go ahead and take the object that he's watching over. He can't take possession of it. But what he could do, if he wasn't watching it, is he could take possession of it and then pay you the money back later on. He'd be allowed to do that. So Tosfos says, there's such a thing as a personal guarantee. He says, even if he doesn't transfer title, okay, but he takes he does a personal subjugation or a personal guarantee on that, where basically he's saying, I owe you X amount of dollars from now until forever. That's not the Kinyan Devarim we were talking about. Okay? That's because they're agreeing, but they don't have any rights to it. But if you do have rights to it, and you do make the Kinyan, then that's going to be chal. So what do? What do you do to ksuba? You sit and you write down all these hischayvus, you write down all of these obligations in there, and then take it as a personal guarantee. You can do that. And Pnei Yoshua says this further. He says that when you are personally taking it on yourself, like one accepts paying back a loan, since legally loans work like that, you can also subjugate your assets to a lien as well. And since that is possible, that's how you can add on all this money to the ksuba. And that's why whenever a person goes ahead and takes on an obligation with some future potential owing, some future potential earnings against future earnings or asset that will be acquired. So even if it's not currently in existence, like the bechor, it's still being personally guaranteed to be transferred. So that works with a kinyan, and that's how a contract would even work. This is also brought down in the Torah of the Shulchan Aruch in Choshen Mishpat 60, and it says that you're normally not allowed to transfer something that's not in your possession, but this is only when you're talking about using terms that talk about selling it or gifting it, okay, or even to mortgage an asset against it. You can't do it if the asset's not there. But if you say that I'm taking it against myself as a loan or a personal guarantee, I can do that. That means that I'm subjugating myself to that loan. And so these type of things will work out just fine. And actually, the Rambam brings down that this was actually the custom in many places, such as an example when they did it in Spain. So the Rambam brings this in Hilchos Mechira, again in chapter 11. Okay, so he says that the way they would get around this is actually to accept a personal penalty. So the Rambam says over here, okay, so you make in making conditions on your property or on your articles that you want to transfer. So you're allowed to make these conditions on it. Okay, if they fulfill it, you get it. If they don't, you don't. Okay, but we said, that you can't try to transfer things that are a smachta, and you can't transfer things that are kinyan devarim. So how do you do this? So he says they had a really cool idea in Spain to get around this. And he says this is chapter 11, and it's halacha number 18. And so he says the following here. Okay. When the sages of Spain desired to make a transaction was based on future considerations, okay, or the asmachta, they had the following guidelines. You would need to make a transaction, a memorial to a transaction, so like the lifting the yamaga, kinyan sudar. And you would say, for example, that you'd be obligated 100 zuz, like in a ksuba. Once you take that obligation and then you make the transaction, you're now making yourself indebted. Okay? And that is as long as this condition is able to be fulfilled. Okay? Or as long as the condition requires you to do certain other items of performance. There are items of specific performance in the contract. So if those things are done, then the obligation is waived retroactively to the time of the original agreement. So it has to start from right now. And if the condition does not be fulfilled, okay, he will then be owed payment as of that moment right now, okay? And so basically they're establishing what is known as a penalty clause in the contract, which is to basically say that you have to follow all of these things or you owe this money. And in effect, a man never pays his wife any of the money in the ksuba ever if they stay married. When he dies, she collects it from his nechasim, from whatever's left over from the estate. But it's because basically if you are accepting it as a personal obligation. Now, a regular penalty clause is the way the Rambam is describing it. You owe money by a certain date, you don't pay it, you pay the penalty. This also gets around other problems like ribis. One is not allowed to charge by law of the Torah, by Torah statute. Mitzvah, it's a law to charge someone interest on their money, but if there's a penalty connected to it, you will pay me the money up until this time. Otherwise, right now, you're accepting a large penalty on yourself. That's a personal obligation, which you can accept upon yourself. I've actually had to rewrite other people's contracts because they had like a little tiny late fee. Well, late fees help, they say. No, it's still inappropriate. And when it's not appropriate, you can't do it. So those are ways in which people can have a good binding contract. So let's say you want to do something else like this. So if you're going to put it, for example, in the ksuba, so in the Even HaEzer, in the laws of ksubos, it's in chapter 50. So when you want to put these type of things into a ksuba, you have to say that when he marries a daughter and he stays married to him, this money will be waived. But if he goes ahead and ends the marriage, then he'll give the groom will give to the man's daughter, to the bride. You're then going to pay a certain amount of money. Okay. So basically, this is also considered a security for the dowry. So that's the same thing that he would do over there. So you can do this for a ton of ways. So that's the contractual way in which one can do this. There's one other way that this can be done, which is through an oath. Oath works great because oath is also a personal obligation. So it's called a shavua, and one is prohibited from taking a false oath. And interestingly enough, this was how the get law was enforced for many years in New York State, until it was challenged as being unconstitutional some 10, 12 years ago. If anyone's ever interested in that, just hit me up for a class on the New York get law. It's very interesting. So it was a very targeted law that basically required that every Orthodox Jewish man had to sign an affidavit that they had removed all barriers to the woman to whom they were married to go ahead and continue to operate. So, and if they did not remove all barriers, they would be held accountable for perjury. And so in Halacha, what we would have is one is forced by the court to stop violating Torah laws. So if you went around eating treif all the time, Beis Din sees you eating at McDonald's, right? They would bring you back to court and force you to stop eating McDonald's. That's what they would do. Otherwise, they would assess penalties. They could even use lashes, even bisman hazeh, right? So take somebody back to. Are you going to stop? No, right? So you're not. We don't do that. But the idea is that a person should be able to enforce the Torah at every single level. So an oath would basically be enforced that way. One could basically bar a person from entering the synagogue. They could bar them from entering any of the kosher establishments, bar them from lots of different things, and tell people not to contact them, etc., etc., etc. This doesn't work for delivering a get, by the way. By a get, you have to have a person has to still consent to the get, so those rules are a little bit different. But if a person's violating an oath, if they're going to continue to violate it, then they can be barred from all types of fun stuff. Keep them away from all the fun things. So that's one other way to sort of get a person to fulfill something. So in the case of Yaakov and Esav, I saw one person actually answer that because Esav basically took it on as an oath, he therefore owed the Bechor to Yaakov. And that's why it became, even though it was something that wasn't in existence and it was not going to smachta, but he's taking an oath. Problem is enforcing it. If the guy dies, you're out of the money. That's the only drawback. You don't collect afterwards. So whereas whereas documents and contracts can be collected posthumously, oaths cannot. So it's not perfect, but then again, collecting money isn't always easy, but it is an option. So we learned today about contracts and how to properly transact them. We learned that while a person should always keep their word and shouldn't back out of contracts, you need to demonstrate definitively that you want this transaction to happen, and therefore you have to make an actual transaction, which is either exchange the money, write a document, do a kinyan sudar, meaning make a memorial of a transaction. These things will demonstrate the person has gemiras das, the person has full intent and full consent to engage in this transaction. In lieu of that, you have to somehow get around it by having a person personally guarantee certain money in a contract. That is possible through a couple of different options. Writing in a contract that person accepts it from now. As long as they continue to do X, Y, Z, they don't have to pay the penalty in the contract. If they fail, they owe the money. So then it sets up a now and then forward, almost like a loan. So a person can do that even if they are watching an object. They could set it up so that way they personally guarantee the object and are liable to the full amount. But if they watch it, they could give it back and collect a different fee to return it. Different than it would be interesting how they would return it. And so then that'll be personal guarantee in that case. And a person could also enforce a contract from now going forward through the use of an oath, because again, it's bound to a person personally. They must make the acceptance on their own person. The difference between the contract and the oath is the contract can be enforced posthumously and the oath may not. Once you're dead, we don't have to force you to fulfill your word. We don't force your descendants. However, generally when you're alive and you make a personal guarantee, that becomes incumbent upon your assets, meaning your estate later on is obligated to make that compensation back. Thank everyone for listening to this class, and I will see everyone next week.